Do you know the difference between a patent or a trademark? I'm Joe Diorio, a U.S. patent and trademark attorney, and clients come to me asking for one but needing the other. Patents protect the product while trademarks protect your brand. A good way to drive this home is through an example. Think of Apple. Apple has trademarks on their brand name, product names, their slogans. So think of the iPhone, the Mac, the MacBook Pro. All of these are protected under the trademark. That's the brand. Apple also has thousands of patents on all of their products with the way they work, the way they look, and the way they function. These patents are broken down into categories: design patents and utility patents. To look at a design patent, think of the original iPhone. It used to have that nice circular home button. This was protected in a design patent because it's limited to the look and feel. So for Apple, them owning that circular home button meant that no other companies, including Samsung, could put in that circular home button. That was the bread and butter for patented Apple iPhones. On the other end, there's utility patents. So think of the iPhone itself. How does it work? Well, it's a cell phone that can make calls, take photographs, search the internet, act as a camera. It could do all these functions, or utility. That is the utility. So to go back to the core question, trademarks versus patents, trademarks protect the brand, patents protect the product. If you're starting a business and you're trying to decide whether or not you need a patent or a trademark, keep that in mind, that patents protect the products, trademarks protect the brand. But what you should also know is most companies have both. If you're looking to develop a new product, it's going to have this unique brand name, right? That's going to be protected through trademark, but the product itself might also be protected through a patent application. If it's a unique design or ornamentation, you're going to go the design patent route. If it provides a new function that consumers can use this device to achieve a new result, or take a better picture, or search the internet that much better, you're in the utility patent realm. In terms of how much patents and trademarks cost, a trademark can cost anywhere from $500 to $1,000, whereas a patent application could cost $5,000 to $10,000. The prices are very different and the scope of protection vary as well. Trademarks are limited to your actual brand. So think of your colors, your slogans, your logos. Whereas a patent application is limited to the function or the utility of the product itself. That will be drafted in a way such that you can protect yourself from competitors making a product that offers similar functions or services. The other main difference between patents and trademarks are the length of how long they can stay active. In terms of longevity, a trademark can last indefinitely. For as long as you're using that brand or that mark being used in commerce in the United States, you will have the trademark registration rights that you can enforce indefinitely. On the other hand, a patent is a limited monopoly that lasts only a specific period of time while your patent has been granted and while it's still active. In terms of when to file a trademark, think of it this way. You can file it before you use your mark in commerce or after. It really doesn't matter to the patent office. If you do it before, you're telling the patent office it's an intent to use application, essentially telling them, hey, I intend to use this brand. Alternatively, if you're already on the market, you're telling the USPTO, hey, I'm using this brand name and I want to protect it for my own rights so that I can tell consumers that anytime they see this mark, it relates to my brand. For deciding when to file a patent application, it's much different than a trademark. Patents must be filed up front before you disclose it to the public. The minute your invention is disclosed to the public, it becomes public domain. Thankfully, in the United States, there's a 1-year grace period from when you disclose to when you're obligated to file a patent application. But remember, not every country has this grace period. So if you were to disclose prior to filing your patent application, you could lose international rights. Be sure to subscribe to my channel for more content like this. We'll be releasing new videos regularly.